Hi, my name is Pratheep Sevanthinathan, otherwise known as Seva. I've been a no-fault insurance litigator for the past 16 years. I initially represented insurance companies, but over the past decade, I've been representing medical providers and injured claimants in no-fault actions. As I gained a reputation for being knowledgeable about insurance litigation and specifically the No Fault Act, I've been invited to lecture on these topics at many seminars, conferences, and educational events. I've also written many articles and treatises about the No Fault Act. And in this video, I'm here to share my knowledge and interpretations of some of the newer aspects of the No Fault Act since it was amended in January 2019, with the final changes taking effect in July of 2021. In this particular video, I will be discussing one specific change to the No Fault Act, the fee schedule. The other sections and topics such as policy caps, PIP opt-out, priority changes, utilization review, and case law updates are discussed in other videos that can be found on my firm's website at www.sevafirm.com. With that, let's talk about the fee schedules. So the most important change to the No Fault Act from a medical provider perspective was the enactment of the fee schedules. The fee schedule was codified in MCO 500.3157, and it basically sets a limit to how much a medical provider can be reimbursed for a service. The fee schedule went into effect on July 1st of 2021, and it applies to services performed after July 1st, 2021. And I think it's important for us to understand why this was implemented process before I tell you exactly how it works and what the issues are that I'm seeing. To take it back to the maybe early 2010s, that first half of the 2010s, there was a big push for fee schedules after the auto insurance became increasingly frustrated with unchecked prices for medical services, and this was one of their main ideas on their wish list when they were lobbying. They felt that they were paying way too much for services for auto accident victims versus non-auto accidents, and it was affecting their bottom lines. The insurers also started the narrative that it was these medical prices that were causing insurance premiums to go up. With no-fault premiums being a major issue for Michigan residents, it was easy for the insurance companies to make this a selling point to the legislators. And the selling point was basically this: if you want to reduce premium rates for auto insurance and make no-fault insurance affordable for Michiganders, then install a fee schedule to keep the medical charges in check. Over the objections of many of the medical providers, and also over the objections of small businesses and injured claimants who pointed out that medical bills were not unchecked and it was not the bills that were increasing the premiums. All of this being pointed out, the fee schedule was passed in 2019. The legislators thought they were doing was keeping the medical costs low, but still allowing providers to operate and remain profitable. This required the assumption that the bills that should be paid are timely paid by insurers. So in a perfect system, if they reduced the charges and set a cap on it, but everything was being paid timely, in theory the numbers worked out so medical providers could still make a decent profit and operate without any major issues. But as we all know, insurers do not pay timely, and a lot of bills go unpaid for months, even years. In fact, the legislators did not realize or understand that medical bills are rarely paid on time, and that most providers have to wait months, even years to get paid, oftentimes after litigation and after their bills have been chopped down by more than a half. There was no real way for providers to force insurers to pay timely. All they had was this attorney fee sanctions and interest, which the legislators thought was a tool, which it really wasn't. It was very clear from my discussions and many other people's discussions with legislators that they didn't know, just how many bills were not paid or paid very late. What the legislators did not realize was that in order to get the sanctions that were supposed to be the penalty for late payment, the providers had to go to trial, and they had to go to trial and win. And as we all know, less than 1% of provider cases go to trial. And once you go to trial, it's a complete crapshoot as to what's going to happen. And so the legislators didn't realize this so-called penalty was actually completely ineffective. In their mind, they just thought that all providers were overcharging and did not realize that the actual reason providers had to charge higher amounts was to internalize the unfair losses and internalize those massive cash flow issues that were caused by slow pay auto insurers. With all of that, the legislators agreed with the insurers over our objections and passed the fee schedule in 2019. So with that in mind, I want to discuss exactly how the fee schedules work. There are two main components to the fee schedules in 500.3157. The first part is for services covered by Medicare. Under subsection 2 of MCL 500.3157, if a provider provides accident-related treatment or services that are covered by Medicare, in other words, if the service has an associated Medicare CPT code, then the provider reimbursement is limited to 200% of the Medicare reimbursement rate. So no matter what you charge, your service will be limited to 200% of Medicare. What does this mean in practice? Well, depending on the service and the geographic area, I have seen about 30 to even 80% reductions in revenue. Losses because, as you know, Medicare does not pay very much. It was not intended to pay a significant amount to medical providers. The second part of the fee schedule in subsection 7 of 3157 states that if you do not provide a Medicare service or a Medicare covered service, then you're limited to 55% of what you're charging on January 1st of 2019. So what does that mean? It means that whatever you're charging for a service back at the start of 2019, you're limited to 55% of this. So for those of you who provide attendant care, case management, transportation, or any of the other services not covered by Medicare, you're required to take a 45% haircut off your bills. This, of course, is very unfair because many of you are struggling to stay afloat before the changes, when you were getting 70% or even 100%, specifically because of the delays and also because you were getting a lot of zeros on a lot of your cases. So getting 55% is going to be very difficult, and I think everyone knows that and recognizes that. One question I get often is, why January 1st of 2019 as the date to look to determine rates? Remember, I just mentioned that it was 55% of your January 1st, 2019 rates. Well, this was done so providers could not change their rates after the law was amended on June 11th of 2019 to offset and compensate for the reductions that the legislature was seeking. So they didn't want you to be able to jack up your rates and get around these reductions after they passed it. However, the legislature did fail to address a very important issue, which is what happens if the provider was not in business on January 1st of 2019? How are those newer providers compensated? It was not addressed at all. And as the law stands now, per my reading, and I believe that the most of my colleagues and on the plaintiff side would agree, As the law stands now, the providers that did not have a charge master or charges to review from 2019, then no fee schedule is applicable. At worst, I think that a judicial review of 3157 would say that you take 55% of your current rates. And I think that's probably what's going to happen if you're a newer company. They're going to take 55% of your newer rates. Although I think there's an argument that can be made that the fee schedule doesn't apply at all if you were not in existence in 2019. Providers can now essentially go back and go in and reform the company, reincorporate into a new company to avoid that January 1st of 2019 reduction. How this will play out in the future, we don't know yet. Of course, the insurers are aware of this, and they're going to be investigating any new companies to see if they were linked to a prior TIN or a prior tax ID number. But for now, that loophole has not been plugged, and it is an avenue for providers who are really struggling to try to get out of this hole. Now, finally, I would like to address some of the most confusing issues that have been coming up regarding the fee schedule. Some of the issues, most common issues that have been asked of me. Does the fee schedule apply to older accidents that took place before the amendment of the No Fault Act? And I think this is the most probably most contentious and most important issue. And unfortunately, the answer currently is yes. Under the rulings that are out right now, and under the general application that most of the courts have been taking, they have been applying this to older accidents. But this is an issue that's actually being litigated currently in the Supreme Court in the Anadary case. And in the Anadary case, the plaintiff is arguing that the application of the fee schedule to accidents that occurred years ago and were covered by a policy that did not have the mandated premium reduction cannot be subjected to fee schedule, because doing so would result in the retroactive application of a law, and retroactive application is impermissible. So the Anadary plaintiffs are arguing that Michigan law doesn't support retroactive application, and therefore insurers should not be able to apply the fee schedules to new claims like new attendant care or new bills for accidents that occurred prior to the no fault amendments. If this Anadary case goes in favor of the plaintiffs, that is going to be a huge windfall for all the medical providers who are treating older accidents. Obviously, if it goes against the plaintiffs and for the insurers, then there's going to be a lot of issues with attendant care, especially. On the flip side of the Anadary case, the insurance company is arguing that this is actually not a retroactive application, and that they are just applying the current laws to new benefits, i.e. their new bills on new services, and therefore we can apply the fee schedule. And unfortunately, the state of Michigan chimed in on this through the Attorney General's office and came out in support of the insurance arguments as well. And that was a huge blow to the plaintiffs and the providers in this case. So it is still going on, and we don't have a decision yet. And as soon as the decision is available, an opinion is available, I will do another video and explain it. But in sum, yes, the fee schedule currently applies to older accidents as well. The next question I've been getting is whether providers need to bill a certain way in order to obtain reimbursement. Specifically, do you need to bill on a certain form, or there's certain codes that are required even if you were not billing with CPT codes before? Is there a certain way that we need to submit bills in order to get paid? Because apparently some insurance companies have been telling, especially attendant care companies, if you don't bill on a particular form, a hospital form, a hospital claim form, then we're not reimbursing you. So the answer to that question is no. There's nothing in the No Fault Act that requires you to bill on a particular form. In fact, the Department of Insurance issued a bulletin confirming this after insurance companies were rejecting payments if not billed on Medicare issued forms. I do believe that the insurers have the right to delay payment if you do not provide the proper code for a Medicare covered service. But if you're a non-Medicare service, you can bill on whatever form you want and however you want. I think a rejection based on the fact that you did not cite to the closest CPT code or bill on a Medicare form for a non-Medicare service would constitute an unreasonable delay. Does the fee schedule apply to services incurred before July 1st but billed after that date? And the answer is no. So as long as your services were performed before July 1st of 2021, it doesn't matter when you bill for them. It only matters the date you perform the service. Finally, the last question I've been asked a lot is, am I still capped at the fee schedule if I litigate my bills? Short answer to that is yes. Unfortunately, there's no way around the fee schedule. Whether you're in litigation or not, regardless of how long you've had to wait for payment, the fee schedule is going to apply. With that said, I am leading a lobby group right now that is working on fix to this. We have introduced a bill into the House of Representatives through a prominent Republican that basically eliminates the fee schedule if not paid within 30 days. Our bill has significant traction. We feel very confident about our chances of passing the bill. We've met with both the House and the Senate at different events. They've both indicated a desire to fix this issue. This is not an issue that they were aware of, and they did not intend for the fee schedule to be compounded by the delay of payments. And they do understand that the fee schedule is hurting providers. They knew that it was going to hurt providers, but they didn't also know that this delay in payment was happening, which makes the fee schedule so much more worse than it should be. And to that end, I would really appreciate your help in passing this bill. And if you want to ensure its passage, there are many ways you can help us out. And if you want to help out in this, please contact me to discuss what you can do to help. Again, my email address is seva@sevafirm.com. That's seva@sevafirm.com. Please let me know if there's any way you can help with our lobbying efforts by either providing data or coming in and supporting us at our events. Finally, I of course must end by asking that if you have any bills to collect or any patients who are in need of an attorney, please think about sending the work my way. Most of you already know our firm has been around for many years. We've been one of the most successful no-fault firms in the state over the past decade. I strongly believe we have the best staff of any law firm, and our outcomes speak for themselves. If you have any work that we can provide for you, whether it's medical provider collections or representation of your patients, give us a call, email me. My phone number is 248-385-5704. My email is seva@sevafirm.com. I'm always open for discussions, referrals, questions, If you just want to bounce a particular claim off me, is this going to get paid or not? If you want to ask which insurance company is higher in priority, whether this bill should be subject to one fee schedule or another, any of those questions, I'm happy to answer at any time. I'm here to be a resource. I want to be a resource for all medical providers, because we should be in this together post No Fault Act changes. And so with that, I thank you for your time, and please check out the rest of our videos at sevafirm.com, www.sevafirm.com. Thank you very much.